Deep. Very serious.
In the First District Court of Appeal, State of Florida, Charles Adelson, Appellant versus State of Florida, Appellee. Appellee's answer brief. Beginning on page 17. Summary of the argument. Because Adelson accepted his jury without reviewing his objection to venue, he cannot argue on appeal that his trial should have been removed from Leon County. But a change of venue was unwarranted since most of the Leon County residents who assembled for Adelson's jury selection had not prejudged Adelson's case. 2. By accepting his jury and not renewing his motion to strike the entire jury pool, Adelson waived his second argument on appeal. But Adelson's motion to strike the entire jury pool was meritless because it was based on isolated comments that could not have influenced all the prospective jurors. 18. 3. Adelson failed to demonstrate the relevance of his exhibit containing more than 400 text messages. In any event, Adelson testified about the content of these messages. It was also better that the jury did not see the vulgar texts within Adelson's exhibit. 4. Adelson's out-of-court statement about knowing how extortion worked was hearsay because they were offered for the truth of the matter asserted, that Adelson had experienced extortion. Adelson is also wrong that his statement fell under the state of mind exception to the hearsay rule. The state of mind exception only applies to statements about the future acts of the declarant, not the past acts of other people. And 5, Adelson's 4 other arguments lack merit, and Adelson does not cite any additional errors in his initial brief. Adelson's cumulative error argument, therefore, fails. Page 19. Argument. 1. A change of venue was unwarranted, and Adelson's argument is procedurally barred. Adelson contends that the trial court should have granted his oral motion to change venue, but Adelson affirmatively accepted his jury, thereby waiving all the objections he made during jury selection. Also, the record shows that Leon County residents were perfectly capable of deciding Adelson's case based on the evidence presented in court. A. Adelson waived his change of venue argument by accepting the jury without objection. At the completion of jury selection, the trial court asked Adelson if he accepted the jury. Adelson replied, "Yes, Your Honor." The trial court then swore in the jury, and Adelson never renewed his motion to change venue. The Supreme Court of Florida said in Armstrong v. State that a motion for change of venue should be renewed at the conclusion of jury selection or be considered waived. Armstrong v. State, citing Martin v. State. Jury selection issues are deemed waived after acceptance of the jury unless the objection is renewed or the jury is accepted subject to an earlier objection. Page 20. See also Hilton v. State, holding that defendant must make a second objection before jury is sworn. Failure to lodge the second objection indicates abandonment of the initial objection. Because Adelson waived all his objections to the jury, this court should reject Adelson's first argument without reaching the merits. B. Adelson failed to comply with the Florida Rule of Criminal Procedure 3.240. Florida Rule of Criminal Procedure 3.240 says that every motion for change of venue shall be in writing and accompanied by 1. Affidavits of the movement, and 2 or more other persons setting forth facts on which the motion is based, and 2. A certificate by the movement's counsel that the motion is made in good faith. Adelson made an oral motion to change venue without providing any supporting documents. Adelson's motion, therefore, was legally insufficient. See Provenzano v. State, holding that because defendant failed to file a written motion, his change of venue argument was unpreserved. Page 21. Footnote 9. Appellant contends that the trial court erred in failing to grant his request for change of venue. However, this issue has not been preserved for appellate review because the motion to change venue was neither written as required by Florida Rule of Criminal Procedure 3.240 and requested by the judge, nor ruled upon by the trial court. Provenzano, end footnote. See also Holsworth v. State, implying that defendant's motion to change venue was legally insufficient because it failed to comply with Rule 3.240. Footnote 10. As a threshold matter, we note that appellant offers no record evidence of compliance with the Florida Rule of Criminal Procedure 3.240 per NB per N1. However, assuming arguendo that appellant's oral motion was procedurally sufficient, we review this claim on its merits. Holsworth. Adelson also failed to file a certificate of good faith as required by Rule 3.240. The Supreme Court of Florida demands strict compliance when a motion requires a certificate of good faith. See Barnhill v. State, holding that the trial court properly denied motion to disqualify judge because counsel's certificate of good faith was insufficient. This court should affirm the trial court's ruling because Adelson's motion was legally insufficient, even though the trial court denied Adelson's motion on other grounds. See Cohen v. Mohawk, Inc. Page 22. If upon the pleadings and evidence before the trial court there was any theory or principle of law that would support the trial court's judgment, the district court is obliged to affirm that judgment. C. If this court reaches the merits of Adelson's motion to change venue, the standard of review is fundamental error. In his initial brief, Adelson argues that the standard of review is abuse of discretion. This is wrong. Adelson failed to preserve his objection to venue because he never filed a legally sufficient motion, and he never renewed his objection before the trial began. If this court considers Adelson's unpreserved argument on the merits, then Adelson has the burden to demonstrate fundamental error. See Smith v. State. Applying fundamental error standard of review where defendant failed to preserve his motion for change of venue. See also subsection 924.051 per N3 Florida statutes limiting unpreserved appellate arguments to review for fundamental error. To demonstrate fundamental error, Adelson must show that a verdict of guilty could not have been obtained without the assistance of the alleged error. Page 23. State v. Delva, quoting Brown v. State. D. Leon County residents were capable of trying Adelson's case solely upon the evidence presented in the courtroom. A defendant seeking a change of venue carries a heavy burden. He must demonstrate that the general state of mind of the inhabitants of a community is so infected by knowledge of the incident and accompanying prejudice, bias, and preconceived opinions that jurors could not possibly put these matters out of their minds and try the case solely upon the evidence presented in the courtroom. McCaskill v. State, quoting Kelly v. State. Adelson argues that he was entitled to a change of venue under McCaskill due to the pretrial publicity surrounding his case. The defendant in Rawling v. State made the same argument unsuccessfully. Danny Rawling gained infamy by brutally murdering 5 University of Florida students in 1990. The Associated Press described Rawling as Florida's most notorious serial killer since Ted Bundy. Page 24, footnote 11. Ron Word, Florida slayer, put to death by injection, Associated Press, October 25, 2006. Despite Rawling's portrayal in the media, the Florida Supreme Court held that Rawling was properly brought to trial in Alachua County, where he murdered his 5 victims. The Supreme Court rejected Rawling's change of venue argument using a 2-prong analysis that considered 1, the extent and nature of any pretrial publicity, and 2, the difficulty encountered in actually selecting a jury. 1. The pretrial publicity surrounding Markel's murder did not prevent Adelson from receiving a fair trial. Adelson cannot meet his burden under the first prong of Rawling to demonstrate that the extent and nature of the pretrial publicity warranted a change of venue. Rawling gives trial courts 5 factors to determine whether pretrial publicity warrants a change of venue. 1. the length of time that is passed from the crime to the trial and when, within this time, the publicity occurred. 2. Whether the publicity consisted of straight, factual news stories or inflammatory stories. Page 25. 3. Whether the news stories consisted of the police or prosecutor's version of the offense to the exclusion of the defendant's version. 4. The size of the community in question. And 5. Whether the defendant exhausted all his preemptory challenges. Rawling. More than 9 years passed between Markel's murder and Adelson's conviction. In Rawling, the court found that a change of venue was unnecessary when 3½ years passed between the murders and Rawling's trial. See Rawling. Adelson failed to make a record as to whether the publicity surrounding Adelson's trial consisted of straight, factual news or inflammatory stories. Most of the prospective jurors learned about Markel's murder through professional news outlets like ABC, CNN, Fox, the Tallahassee Democrat newspaper, and WCTV, a local television station affiliated with CBS. Nothing in the record suggests that these professional news outlets said anything inflammatory about Adelson. The pretrial publicity in Foster v. State was more inflammatory than any of the media coverage surrounding Adelson's case. Page 26. Still, the Supreme Court of Florida held that Foster was not entitled to a change of venue. Foster was the leader of a group of young men in Fort Myers that called themselves the Lords of Chaos. These young men murdered a high school band teacher who caught the Lords of Chaos vandalizing a school. Foster moved to change venue because of the negative publicity leading up to his trial. As part of his motion, Foster provided newspaper articles and television broadcasts reporting his plan to go to Disney World and kill black tourists. One of these articles referred to Foster as a psychopath, Opie with a gun, and a Jekyll and Hyde type character. Another newspaper article published just 2 days before Foster's trial read, "Old Sparky's hot jolt may await Foster." The same article called Foster a redneck, racist, and a gun-crazed punk. Despite such negative publicity, the court held that the media coverage as a whole did not reach such an inflammatory level to have irreversibly infected the community so as to preclude an attempt to secure an impartial jury. Adelson also failed to demonstrate that the publicity surrounding his trial supported the state's viewpoint. Nothing in the record suggests that the major news outlets served as a mouthpiece for the police or the state attorney's office. Page 27. One prospective juror did volunteer that former prosecutor and court TV host Vinnie Politan had expressed negative views about Adelson, but this juror could not remember what Politan said. The juror also took Politan's negative view of Adelson with a grain of salt. Politan is from New Jersey. He's a prosecutor. He has opinions about a lot of people, and they're normally not positive. Adelson cannot argue that his trial occurred in a small community. According to the United States Census Bureau, Leon County had 292,198 residents in 2020. Footnote 12, U.S. Census Bureau 2020 Census Population and Housing Map, Florida. By comparison, there were 181,596 residents in Alachua County in 1990, 4 years before Danny Rawlings' trial. Footnote 13, U.S. Census Bureau 1990 Census of Population, General Population Characteristics, Florida. End footnote. If Rawlings could receive a fair trial in 1994 in Gainesville, then Adelson could receive a fair trial in 2023 in Tallahassee. Page 28. Adelson's use of preemptory challenges also undermines his argument. Adelson did not use all 9 of his preemptory strikes until the end of jury selection, when he used his leftover preemptory challenges to backstrike 2 prospective jurors. At this point, the state and Adelson had already accepted 12 jurors for the main jury. If the minds of Leon County residents were truly infected, then Adelson would have run out of preemptory challenges long before 12 jurors were seated. 2. Adelson had no difficulty in selecting a jury. Adelson cannot meet his burden under the second prong of Rawling, which addresses the difficulty in selecting a jury. While 22 prospective jurors said they could not be fair, 30 of the prospective jurors had never heard of the Markel trial. Also, whenever a prospective juror expressed an opinion about Adelson's guilt, the trial court erred on the side of caution. Once a prospective juror has provided that opinion, it definitely skews towards their excusal. At the end of the initial screening, Adelson agreed to 58 prospective jurors for the final phase of jury selection. Page 29. E. Adelson's case was not like Manning v. State. Adelson relies on Manning v. State, one of the few cases where the Supreme Court of Florida found that a trial court abused its discretion by not granting a change of venue. The defendant in Manning was a black man accused of murdering two well-liked Caucasian deputies in Columbia County in 1976. The court described these murders as the main topic of conversation in this small rural community. At that time of the 1980 census, 35,399 people lived in Columbia County. Footnote 14, Florida Office of Economic and Demographic Research, Columbia County. End footnote. Because of the local animosity towards Manning, the public defender's office recused itself, and Manning had to be moved to a jail in another county for his safety. The court described the news coverage surrounding Manning's case as intense, adding that both the police and the prosecutor made press releases relaying their version of the deputy's murders. The court also noted the extent to which Manning's jury pool was tainted, quoting, "Every member of this prospective jury had knowledge of ex parte statements of the evidence against the accused." Page 30. Adelson's case was nothing like Manning. Tallahassee in 2023 was not a small rural community. None of the prospective jurors interviewed mentioned press releases from the police or the state attorney's office. Not every prospective juror had heard of Markel's murder or Adelson's prosecution. Also, Adelson's case did not involve the racial hostility that influenced the Supreme Court's holding in Manning. Page 31. 2. Striking the jury panel was unnecessary, and Adelson's argument is procedurally barred. Adelson argues that the trial court should have struck the entire jury pool because a few prospective jurors made comments about Adelson's case in the jury waiting room. But Adelson affirmatively accepted his jury, thereby waiving all the objections he made during jury selection. Also, the comments by the prospective jurors did not warrant striking the panel because those jurors did not mention facts that would not otherwise be presented to the jury. A. Adelson waived his argument by accepting the jury without objection. Adelson affirmatively accepted his jury without reserving his objection to the jury pool. Adelson also failed to renew his motion to strike the jury pool after the trial court swore in the jury. This court made clear in Johnson v. State that a defendant must renew any objection to the jury pool before the jury is sworn in. Appellant claims the trial court abused its discretion in denying his motion to strike this venire. This claim is not preserved for appeal because the appellant's motion was not renewed once jury selection was complete or before the jury was sworn. Page 32. See also Hayes v. State, holding that defendant waived his motion to strike the entire jury pool because defendant did not renew his objection before the jury was sworn. Because Adelson waived his objection to the jury pool, this court should affirm Adelson's conviction without considering his arguments on the merits. B. Adelson failed to comply with Florida Rule of Criminal Procedure 3.290. Florida Rule of Criminal Procedure 3.290 requires that a challenge to the panel shall be in writing and shall specify the facts constituting the grounds of the challenge. Adelson's oral motion was legally insufficient. This court recognized the importance of a written motion in Cargill v. State, holding that defendant's objection to the jury panel was not open for consideration on review because it was not in writing and untimely. Because Adelson failed to comply with Rule 3.290, his argument is either waived or unpreserved, page 33. C. If this court reaches the merits of Adelson's argument, the standard of review is fundamental error. Adelson argues that the standard of review is abuse of discretion. Adelson is mistaken because he failed to preserve his motion to strike the jury pool and failed to file a legally sufficient motion. Adelson's argument is unpreserved. Adelson therefore has the burden of demonstrating fundamental error. See subsection 924051, paren 3, Florida statutes, limiting unpreserved arguments to fundamental error review on appeal. To demonstrate fundamental error, Adelson must show that a verdict of guilty could not have been obtained without the assistance of the alleged error. Delva, quoting Brown. D. The isolated comments of a few prospective jurors did not warrant striking the entire jury pool. Adelson moved to strike the jury pool after a handful of prospective jurors made comments about Adelson's case. The Supreme Court of Florida said in Johnson v. State that, quote, in order for the statement of one venire member to taint the panel, the venire member must mention facts that would not otherwise be presented to the jury. Page 34. Most of the prospective jurors cited in Adelson's brief only spoke about facts that were eventually addressed during Adelson's trial. One of the prospective jurors said Markel's murder happened 9 years prior. Another member of the jury pool incorrectly believed that Adelson was a federal case. Other members surmised that they had been called for a case concerning the murder of an FSU professor. One of these prospective jurors mentioned Markel's kids and a divorce. Johnson makes clear that these comments were no reason to strike the entire pool of prospective jurors. Quote, no venire member in Johnson's case mentioned a fact that would not otherwise be presented to the jury. Johnson. Adelson also complained that 2 prospective jurors expressed their opinion that Adelson was guilty. But the Supreme Court said in Johnson that a venire member's expression of an opinion before the entire panel is not normally considered sufficient to taint the remainder of the panel. The prospective jurors who expressed opinions about Adelson's guilt could not have poisoned the whole jury pool. One prospective juror merely mentioned to another jury pool member, I think he did it. The other prospective juror expressed his opinion that Adelson was guilty and that jury selection would last all day. Page 35. These 2 comments about Adelson's guilt pale in comparison to the statements at issue in Brower v. State, where a group of prospective jurors discussed hanging the defendant instead of sitting through a long trial. While the Brower court found these comments shocking, the court affirmed, holding that the defendant received a fair trial from jurors who had not acted offensively and were not otherwise tainted. Like the defendant in Brewer, Adelson received a fair trial from well-mannered, untainted jurors. Page 36. 3. Adelson's text messages reflecting normal communication were irrelevant. Adelson argues that he should have been allowed to show the jury over 400 text messages taken from his phone. None of the text messages Adelson sought to introduce into evidence contained any relevant information. Also, some of Adelson's texts contained sexual, racist, and misogynistic references that would have embarrassed Adelson had they been admitted. In any event, Adelson suffered no harm because he testified about the content of his text messages. A. Adelson invited the error he alleges on appeal. While the trial court would not admit all of Adelson's 400-plus text messages, the court said it would consider admitting individual messages that were relevant. But Adelson never offered any individual text messages for the trial to consider. Thus, the trial court gave Adelson an avenue to enter relevant text messages, but Adelson declined to take it. This court, therefore, should reject Adelson's argument under the invited error doctrine, see Sullivan v. State, quoting, "It is well-established law that where the trial judge has extended to counsel an opportunity to cure any error, and counsel fails to take advantage of the opportunity, such error, if any, was invited and will not warrant reversal." Page 37. B. If this court considers the admissibility of Adelson's text messages, the standard of review is fundamental error. Adelson's initial brief argues that the trial court should not have excluded his text conversations with McBonowa, Donna Adelson, and Wendy Adelson. But Adelson's proffered texts also included conversations with his friends, business partners, and other medical professionals. While the trial court would not admit all 400-plus text messages, the court expressed its willingness to consider any relevant nuggets that went to Adelson's state of mind. Despite the trial court's offer, Adelson proceeded without proffering any individual text conversations he had with McBonowa, Donna, or Wendy. Because Adelson failed to proffer any individual text messages, the trial court never ruled on any text conversations involving McBonowa, Donna, or Wendy. Adelson's argument is therefore unpreserved. See Louviere v. State, holding that defendant failed to preserve his appellate argument where defendant never obtained a clear ruling excluding evidence. Page 38, footnote 15, quoting, Louviere's argument fails because he did not preserve the issue on appeal. Defense counsel did not obtain a clear ruling on his objection to the exclusion of Louviere's testimony on the nonviolent nature of his prior convictions. Although the trial court twice stated that it would sustain an objection to any question about the nature of Louviere's prior felonies, it never had a chance to do so because defense counsel never asked the question. End footnote. Newton's v. South Florida Baptist Hospital, holding that plaintiff waived his objection by failing to obtain a clear ruling on his objection. If this court considers Adelson's unpreserved argument on the merits, it should apply the fundamental error standard of review, see Steinhorst v. State, except in cases of fundamental error, an appellate court will not consider an issue unless it was presented to the lower court. To demonstrate fundamental error, Adelson must show that the outcome of the trial would have been different had the trial court admitted Adelson's text conversations with McBonowa, Donna, and Wendy. See Everett v. State. Fundamental error is error that undermines the confidence in the trial outcome and goes to the very foundation of the case. Page 39. C. Adelson never proffered any text messages from July 2014. Adelson's initial brief argues that his text messages showed that Adelson and his alleged co-conspirators were communicating normally during and around the time of the murder. But Markel's murder occurred in July of 2014, while Adelson's exhibit of 400-plus text messages detailed conversations that occurred between June 2nd and June 7th, 2014. These texts from June 2014 corresponded to the hitman's first unsuccessful attempt to kill Markel. Adelson's attorney told the trial court he planned on doing the same thing for July 14 through 19, but Adelson never proffered any text messages from July of 2014. This court therefore should reject Adelson's argument regarding the relevance of his July 2014 text messages. See Martin v. State. Quoting, without a proffer, an appellate court cannot determine whether an error occurred, let alone a fundamental error, unquote. Page 40. D. Adelson's text messages were irrelevant. According to Adelson, his 400-plus text messages were relevant because they established reasonable doubt and demonstrated his state of mind. Adelson is wrong on both points. Generally, any evidence that could establish reasonable doubt is admissible, and a close call should be resolved in the defendant's favor as long as there is a possibility of the evidence creating a reasonable doubt, May v. State. But evidence as to immaterial matters is inadmissible for any purposes, Erb v. Carroll. Adelson could not establish reasonable doubt by showing that he texted people about immaterial matters, just because Adelson never texted McBonowa, Donna, or Wendy. Footnote 16. Besides being irrelevant, Adelson sent suspicious texts on June 7, 2014, the day after the hitmen returned to Miami after their first failed attempt to kill Markel. On that day, Adelson texted McBonowa, "Are you okay? Call me." Later that day, Wendy sent a text to Adelson saying, "What's up? Call me." To this, Adelson responded, "Sure." End footnote. about murder did not mean that Adelson was unaware of the plot to kill Markel, see May, holding that defendant could not use financial audit reports to show he never committed fraud when the proffered audits would not have detected the fraud alleged by the state. Adelson's texts were also irrelevant because they did not support his theory of defense, that Magbanua and the hitmen killed Markel in a scheme to extort Adelson, see Arroyo v. State, holding no abuse of discretion in excluding text messages that were marginally relevant and not relevant to the defendant's theory of the case. Adelson's other argument is that his text messages demonstrated his state of mind. This is wrong. Section 90.803 Florida statutes recognizes two types of hearsay statements that are relevant to demonstrate the declarant's state of mind. One, statements that prove the declarant's state of mind at a time when such state is an issue in the action, and two, statements that prove or explain the declarant's subsequent conduct, subsection 90.803 paren 3 paren A Florida statutes. The thoughts expressed in Adelson's text messages were not relevant to any issue in the action. Adelson's text also failed to prove or explain Adelson's subsequent conduct. See Penlaver v. State. Statements admitted during the state of mind exception to the hearsay rule are properly admitted only if they involve the state of mind of the declarant and there is evidence demonstrating that the declarant acted in accord with the state of mind or intent. Page 42. The fact is that Adelson did not offer his text messages to demonstrate his state of mind. Instead, Adelson tried to use his texts to show that he had not aided Magbanua and Garcia in the plot to murder Markel. But a defendant cannot offer state of mind evidence to prove prior conduct. Chief Judge Irvin recognized in Reed v. State that a statement of the declarant's then existing state of mind is admissible to prove or explain the declarant's subsequent conduct, but not his prior conduct. Irvin, see Judge concurring, quoting Charles W. Earhart, Florida Evidence. Like Adelson, the defendant in Cotton v. State tried to use his self-serving statements to show that he was unaware of a crime. The police caught Cotton with a package containing a cocaine drop during a traffic stop. Cotton told the police that the driver had just handed him the package and that he had no idea that it contained cocaine. Cotton argued that his denial of guilty knowledge to the police came within the state of mind exception to the hearsay rule. Page 43. The 4th District Court of Appeal rejected that argument. Instead, the 4th District held that Cotton's statement was precisely the type of self-serving exculpatory statement that has been traditionally regarded as inadmissible hearsay because of his lack of reliability and trustworthiness. While Adelson's texts were not expressly exculpatory, Adelson offered his texts for the same purpose as the statements proffered in Cotton, to show that Adelson was unaware of a criminal act. But like the statements proffered in Cotton, Adelson's texts were not reliable or trustworthy evidence of Adelson's ignorance of the plot to kill Markel. E. The trial court's exclusion of the text messages did not harm Adelson. This court should affirm because the trial court's ruling did not prejudice Adelson. See subsection 924.33 Florida statutes requiring appellate courts to affirm unless an error was committed that injuriously affected the substantial rights of the appellant. The trial court's exclusion of Adelson's text messages was harmless for 4 reasons. First, Adelson testified that he reviewed every text message he sent and received between June 2 and June 7 of 2014, and none of those texts discussed Markel's murder. Page 44. The text messages themselves would have been cumulative to this testimony. See Calhoun v. State, holding that any error in excluding defendant's self-serving statements was harmless beyond a reasonable doubt where the statements were cumulative to other information elicited during the trial. See also Linnick v. State, holding that exclusion of father's testimony about defendant being a Bosnian refugee was harmless because some of this testimony was heard by the jury. Second, the texts would have likely angered the jury. Some of Adelson's texts contained racist words and references. Other texts were sexually explicit. Still others were misogynistic. The trial court's exclusion of Adelson's distasteful texts avoided their prejudicial effect. Adelson, therefore, cannot complain that he suffered prejudice due to the trial court's ruling. See subsection 924.051 Florida statutes. A judgment or sentence may be reversed on appeal only when an appellate court determines, after a review of the complete record, that prejudicial error occurred. Page 45. Third, the jury heard recordings of Adelson speaking about Markel's murder after the bump. This evidence showed that Adelson preferred to speak about Markel's murder either over the phone or in person. Adelson also spoke very cautiously about Markel's murder, often using coded language. For example, Adelson had a phone call with Donna where he told Adelson that it's clear what's wanted. This TV is probably about 5. Donna's use of TV is significant because Adelson had joked that buying Wendy a TV was cheaper than hiring a hitman. Adelson knew exactly what Donna's coded language meant, and he responded, "They asked you for $5,000? Another example was Adelson's conversation with Mike Bonawa at Dolce Vita restaurant, where Adelson spoke of a horrible crime involving a gun. During this conversation, Adelson posited a hypothetical resembling Markel's murder, where the killer would rent a car and drive to Orlando to rob a McDonald's. Because Adelson was so cautious about discussing Markel's murder over the phone and in person, the jury would not be shocked to learn that Adelson avoided discussing the murder over text. Page 46. Adelson's attorney even admitted during closing arguments that it did not make any sense for a guy who was about to murder someone to go around town and advertise it. Fourth, Magbonawa's testimony crushed Adelson's claim that he was unaware of the plot to kill Markel. Around Halloween of 2013, Adelson asked Magbonawa, "Do you know anybody that can harm someone?" In response, Magbonawa said, "Yes," and kind of left it alone. Later, Adelson told Magbonawa that he wanted Wendy's husband killed. Adelson claimed that Wendy's husband was a terrible man and making his family go through a lot custody-wise with his sister. According to Adelson, this turmoil had caused his mother to stop eating and sleeping. Adelson added that his father's health was also in decline. Magbonawa said that Adelson became a little more adamant about getting this job done in June of 2014. Adelson initiated Markel's murder by giving Magbonawa a manila envelope containing the information Garcia would need to find Markel. Adelson took steps to ensure that his DNA and fingerprints would not be on the envelope or its contents, and he advised Magbonawa to do the same. Page 47. It was clear from Magbonawa's testimony that Adelson kept his discussion of the murder plot to a minimum and preferred to communicate about the murder in person. Magbonawa's testimony also showed that Adelson took measures to conceal his connection to Markel's murder and the hitmen. The jury, therefore, would have been unsurprised to learn that Adelson did not text about the plot to kill Markel. Page 48, Issue 4. Adelson's out-of-court statement about extortion was inadmissible hearsay. Adelson claims that the trial court should have admitted a phone call where Adelson spoke with Donna about extortion. In this call, Adelson told Donna, "I'm just telling you it's not done like that. It's not. I know for a fact it's not. It's not done like that at all. It's not done in such a nice manner." According to Adelson, this statement proved he had been the victim of extortion. Adelson's statement in this phone call was inadmissible hearsay because it was offered for the truth of the matter asserted, that Adelson had experienced extortion. Also, Adelson's statement did not fall under the state of mind exception to the hearsay rule because it described the past conduct of other people. A. The standard of review is mixed because Adelson never argued that his statement was not hearsay. When the trial court asked Adelson's lawyer why Adelson's statement was not inadmissible hearsay, Adelson's lawyer responded that the statement went to Adelson's state of mind. In other words, Adelson argued that his statement was hearsay, page 49, but subject to an exception to the general rule prohibiting hearsay evidence, footnote 18. See Sigismondi v. State, recognizing statements of a declarant's then existing state of mind as an exception to the hearsay rule, quoting section 90.803, paren 3, paren A, paren 2, Florida statutes, end footnote. But on appeal, Adelson makes an additional argument. His statement was not hearsay because it was not offered for the truth of the matter asserted. This argument is unpreserved because Adelson did not raise it in the trial court, see Reynolds v. State, holding that defendant failed to preserve appellate arguments that statements were not offered for the truth of the matter asserted when defendant did not make that argument in the trial court. Adelson's argument that his statement was not hearsay is subject to fundamental error review. See subsection 924.051 paren 3 Florida statutes, limiting unpreserved arguments to review for fundamental error. This court should review the trial court's rejection of Adelson's state of mind argument for abuse of discretion. A court abuses its discretion when no reasonable person would take the position of the trial court on a matter concerning any findings which are supported in the record. Harris v. State. Page 50. B. Adelson's statement alluding to extortion was hearsay. Adelson argues that his statement alluding to extortion was not hearsay because it was not offered for the truth of the matter asserted. Adelson is wrong. Adelson wanted the jury to believe his statements about extortion was true, so his statement was hearsay. This court recognized in Chapman v. State that if an out-of-court statement is offered in court to prove the truth of the facts contained in the statement, it is hearsay, quoting Charles W. Earhart, Florida Evidence. C. Adelson's remarks about extortion did not fall within the state of mind exception to the hearsay rule. According to Adelson, his statement about extortion fell under the state of mind exception to the hearsay rule. Adelson's argument fails for 3 reasons. First, Adelson's statement did not fall under the state of mind exception because the statement did not reflect Adelson's mental or physical state. Section 90.803 paren 3 allows hearsay evidence that shows the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, motive, design, mental feeling, pain, or bodily health. Page 51. Subsection 90.803 paren 3 paren A Florida statutes. Instead of offering his statement to reflect his state of mind, Adelson offered his statement to prove that Garcia and Magbanua extorted him. Second, Adelson wanted to use his statement to show he had been extorted in the past, but the state of mind exception to the hearsay rule only encompasses future conduct, not prior conduct. See Reed. Urban C.J. concurring, a statement of the declarant's then existing state of mind is admissible to prove or explain the declarant's subsequent conduct, but not his prior conduct, quoting Charles W. Earhart, Florida Evidence. See also R.J. Reynolds Tobacco v. Hamilton. A hearsay statement which recounts observations made previously is by definition an after-the-fact statement of memory and expressly excluded from the state of mind exception, citing 90.803 paren 3 paren B Florida statutes, prohibiting admission of any after-the-fact statement of memory or belief to prove the fact remembered or believed unless it relates to declarant's will. Page 52. Third, Adelson could only use the state of mind exception to explain his own conduct, not the conduct of another. Adelson, therefore, could not use his own out-of-court statement to show that Garcia or Magbanua extorted him. See Shepard v. United States, holding that victim's statement, Dr. Shepard has poisoned me, did not fall within state of mind exception. Evidence of the declarant's state of mind is only admissible to explain the declarant's actions, not as proof of an act committed by someone else. See also Cybers v. State. The courts of this state have repeatedly held that out-of-court statements cannot be used to prove the state of mind or motive of someone other than the declarant. D. Excluding Adelson's phone call did not prejudice him. Adelson must demonstrate that the trial court's ruling excluding his phone call was an error that injuriously affected his substantial rights. See subsection 924.33 Florida statutes. Adelson fails to meet this burden for 4 reasons. First, Adelson's statement to Donna suggested he was familiar with the concept of extortion, not that he had been the victim of extortion. Page 53. but most people are familiar with how extortion works, even if they have never been extorted. Adelson's statement, therefore, was marginally relevant at best. Second, Adelson was allowed to testify about the contents of his phone call with Donna. Adelson told the jury that he advised Donna that it's not done this way. I know for a fact, and I'm 99% sure it was what I thought it was. Third, the jury heard Adelson make an almost identical statement to Donna in one of the phone calls that the state published. The jury heard the state's call R, where Adelson and Donna discussed the bump. In that call, Adelson told Donna, I actually do know how these things are done, and that was the same thing that I said. It's not done like this. When Adelson took the stand, he explained the above statement. According to Adelson, he meant that it's not the same people that extorted me that are extorting Donna. It's clearly not the same as the first extortion. Fourth, other phone calls between Adelson, Magbanua, and Garcia disproved Adelson's story about being extorted. After the undercover FBI agent approached Donna, Adelson called Magbanua and explained that he believed Donna was being blackmailed. Page 54. During this conversation, Adelson brainstormed with Magbanua as to who might blackmail Donna, but Adelson never said anything that implied he had been extorted too. Later, Adelson called Magbanua to tell her about a birthday present Adelson had left for Garcia. Adelson said, if you don't think it will cause anything, you can tell him it was from me when he opens up the present. In another call between Adelson and Magbanua, Adelson revealed that he was aware but not surprised that Katie's baby daddy, Garcia, called the undercover FBI agent on Adelson's behalf. In a subsequent phone call, Magbanua told Garcia, I told Adelson like, you'd help him. You know, I'll try to help out. Garcia replied, you know what? I'll take care of it. Later, Adelson called Magbanua to let her know that the undercover agent was a pot-bellied pig. In this call, Adelson asked Magbanua, you know what a pig is? These phone calls did not depict Adelson interacting with his extortionists. Instead, these calls revealed that Adelson, Magbanua, and Garcia were co-conspirators that cooperated to determine the identity of the undercover FBI agent. Page 55. Issue 5. Adelson's cumulative error argument fails because his other arguments are procedurally barred, meritless, or both. Adelson argues that the alleged errors in his 4 other arguments resulted in a cumulative error that deprived Adelson of a fair trial. But all of Adelson's other arguments are procedurally barred, meritless, or both. Outside of his 4 main arguments, Adelson alleges no additional errors that affected his trial. Adelson's claim of cumulative error, therefore, necessarily fails. See Alsager v. State, where the alleged errors urged for consideration in a cumulative error analysis are individually either procedurally barred or without merit. The claim of cumulative error also necessarily fails, quoting Bush v. State, Israel v. State. Page 56. Conclusion. Any Florida jury would have convicted Charles Adelson for effectuating the murder of Daniel Markel. Adelson was an essential link between Markel and the man who killed him, Sigfredo Garcia. Catherine Magbanua was the other essential link between Garcia and Markel, and her testimony explained how Adelson was the driving force that caused Markel's death. Adelson's text messages and phone calls could not have changed the outcome of his trial. This court should affirm Adelson's convictions for first-degree murder, conspiracy to commit murder, and solicitation to commit murder.